Okay.
Yes.
Regarding item number 4, the concept of other side. The matter may come up on serious and the SPSNL in
My lord, he is kind asking for accommodation on the ground of the Advocate General. My lord, difficulty is I am, my lord, giving the consent so that, my lord, he fixes a short date. My lord, he please for a short date. Can it be on 11th? My
Yes, I agreed by learned advocate for both the parties. It's the place the matter 11.
lord, like.
on behalf of the school, I think
Yesterday you have mentioned one matter without taking consent from the other side.
my lord, people has to inform me that today also inform me that other side was informed.
No, we will not allow you. We will call the matter.
But he is out of
Yesterday you misled the court.
May please, your lord. In regard to item number 5 of today's list, my lord, may I pray for a week's time to file a withdrawal petition, my lord? I have instructions. I am filing a withdrawal petition in a week. I have instructions from my client,
Why withdrawal petition? is
my
not
lord,
accepted?
to bring in the developments which have taken place post filing of and during pendency of the writ petition, my lord. I have informed Mr. Samrat Saha, who appeared for the.
Mr. D. Chakraborty, learned counsel for the petitioner. You inform the other
I
side
have informed.
with concern for the other side. Press for listening the matter after a week. First, enable him to file one withdrawal petition. Here it allowed. That is the matter after 1 week.
My lord, deeply obliged.
May I please, with the consent from the other side, I beg to mention item number 20, sir.
Except for 20. Yes.
Because my lord, it's not from there is there.
Yes.
My lord, there is there is this.
Yes.
They are taking time. Only they are sending a book. Lordship, we have been engaged newly in this.
Okay.
That is. Okay, madam.
When can it be listed?
After 3 weeks.
After 3 weeks. Then we have to release the matter from further. Because there is no notification of the race. After 1 month, we have to release the matter from further.
My lord, already you have hard.
Okay. For the pair being made by learned counsel for both the parties, it is the matter.
Yes.
You offer the petition.
I'm for that.
It's not- You offer the appellate. The pair. Sir,
TJ.
learned counsel, appellate. Having not been objected by on the learned assisted by reason the place the matter was solicited.
On 20 November. Much obliged.
May please the Lordship. Lordship, I beg to mention for listing or listing of a repetition. Lordship, since the petitioner is not getting
Listing before the senior court. Senior
May I please, Your Lordship, I beg to mention item number 25. Lordship, my senior is out of station. Kindly
item
met
number.
item number 25, Your Lordship.
Right.
Kindly matter may be taken on 6th of November, Your Lordship.
6th of
November.
is your name, please?
P. Roy.
Learned counsel appearing on behalf of Mr.
K.M. Hassan.
K. M. Hassan. Learned counsel for the respondent of part 2. To inform the other side,
Yes, Your Lordship.
with consent of the other side, press for this after on 6th of November. 6th of November.
6th November.
There.
Oh, bless you, Lordship.
Lordship, I would like to beg item number 21. On behalf of PK Day petitioner, kindly list the matter after a week. His leave application is already reflecting in the court case. He's out of station. Petitioner
It's your name, please?
D. Hazarika.
T.
Lordship,
Hazarika, learned counsel appearing on behalf of Mr. T.K. Day. Learned counsel for the appellate. To inform the other side.
yes, sir. Lordship, I am for the respondent. Lordship, that may be fixed. It's a further matter, my lord.
Which concept the other side tells us the matter when
Uh, Lordship, 4th of November.
or
Our speak not possible.
So,
Fourth of November already lot of cases are
On 18 November.
okay.
18.
Oblige your lordship.
Lordship, with the consent of the petitioner, Lordship, I beg to mention item number 6, Lordship. In this matter, Lordship, we are supposed to file an additional affidavit, Lordship. But Lordship, what happened, Lordship, we have replaced the file, but right now we have fixed it out, Lordship. So I want to file the affidavit, Lordship, additional affidavit. So Lordship, can it be taken up the next week, Lordship?
Date may be fixed, your lordship. You're supposed
I need, yes, the
to
additional.
obtain instruction also.
Okay, Mr. The Upamanya learning something of the product
I-
verification department with concern from the petitioner, else for listing the matter after the petition. So as to enable it, file one additional affidavit.
Date may be fixed, your lordship.
Where the listing the matter.
On 31st October.
31st. Highly okay.
Items for admission, item 1, part A.
Please, your lordship, my lord. My lord, in response to the affidavit in opposition, my lord, filed by the respondent number 2, my lord. The director, my lord, concerned director, my lord. I have filed, my lord, one affidavit, my lord, in reply, my lord, on 16th of September, my lord. And my affidavit says something else, my lord, regarding the enquiry, my lord, which was shown to be carried out, my lord, on a particular date, my lord. We remain absent. I, along with the assistant teacher of the school, and I admitted in my affidavit as well as in my oral submission also, my lord, that we had to remain absent because of a sudden demise of one of our relative, my lord. And my lord, the crux of the issue is absolutely different, my lord. The impugned order worship is find at the main writ petition, my lord, the last page of the writ petition. That says that, my lord, in the year 2016 and 17, there was no enrollment in the school, my lord. Page 99 of the writ petition, my lord. It says that, my lord, in the year 2016 and 17, there was no enrollment on UDAS in the database maintained by NUPA for the year 2016 and 17. my lord. And whereas, my lord, the inspection report, which was never disputed by the respondent authorities, my lord, that my lord will find at page 84, my lord, annexure 18, my lord. Page 84, my lord. This was an inspection report, my lord, which was issued by the SI of schools, my lord. And in the year 2016, 17, my lord, today, 5th of my lord, May, my lord, 2017, my lord, this inspection report was issued. It says that, my lord, on the day of inspection, my lord, there were 160 number of students which were found
So
in school.
this annexure 24 page number 97 is the impugned order.
Impugned order, my lord.
Section report is the page number.
Page number 84, my lord, annexure 18, my lord. Inspection was carried out on, my lord, 5th of May, my lord, 2017, my lord. As per this inspection report, the number of students in the school was found to be, my lord, 160 numbers.
And on what basis this inspection was carried out?
My lord, that was an inspection, my lord, which was carried out long back, my lord, by the inspection, by the SI of schools, my lord. Regarding, my lord, the presence of the students and the infrastructure of the school and the number of teachers of the school, my lord. In fact, in the
No,
serial number
was it
120.
a routine inspection or there was direction from higher authority?
That we do not know, my lord. It was carried out on 2017, my lord, since it was carried out. It was carried out by himself, my lord, by the SIF schools. my lord. And as per this report, my lord, this impugn order is not sustainable in the eye of law, my lord, because the only ground, my lord, of rejection is that in the year 2016 and 17, there were, my lord, no students in our school.
In
Lord.
which part of the impugn order it is reflected?
In the last page of the impugn order, page 99, my lord. Fourth line, my lord.
Pardon?
Fourth line, my lord. From the top, my lord, it is fourth line. Since the enrollment position of the school during the year 2016-17 is shown as no enrollment on UDAS in the database maintained by the NUPA for the year 2016 and 17. Hence, the committee decided to stand by the decision of the earlier SLSC and joint committee constituted by the government, and therefore the committee and also decided that the claim of the petitioner school for provincialization of services of the teachers against so and so school as per provincialization of service
What is,
2007.
what is the report of this? You guys?
That is not with us, my lord. And in fact, my lord, I am referring to one another, my lord,
No,
communication.
No, no. Tell me. Total of enrollment or you guys
UDAS.
in the database maintained by of
Yes.
Far.
My
for
lord,
the year 2016 and 17.
17.
Where is this report?
That report is not with us. There is even in the background, there is a story, my lord. Earlier, my lord, there were two number of schools, my lord, having same name, my lord. And because of that dispute, my lord, our DIAS code was captured and taken back by the respondent authority, my lord. That has been rightly reflected by the DEO's report, my lord. Page 96, my lord. Annexure 23, my lord. 96. my lord. Lord, she will kindly come to page 96, my lord, annexure 23, my lord. This authority had, my lord, requested, my lord, the mission director, SSA, my lord, to issue a fresh DIAS code or either a renewed or a fresh DIAS code for the school of the petitioner, my lord. In the last paragraph has been mentioned. In the DIAS code for the year 2009 and 10 also, my lord, the name of the number of the DIAS kit was also mentioned, my lord. 0102713.
No,
This is the only reason, my lord,
no,
since it, my lord.
about the this this order is based off of this you guys report. Where is that report?
My lord, that report has not been communicated to us, my lord. Since the, my lord, our DIAS code was, my lord, it was blocked by the, my lord, mission director, my lord. It was never released, my lord. There was a letter of request by the,
Report is available with you.
Look, right now, right now, I don't refer this UDAS data has been kept by the, look after by the SSM.
this is mission
They
director.
will verify.
Who is appearing for SSA? SSA is a party here.
SSA party. my lord. And this was never, my lord, released by, even though there was a letter of request by the DEO, my lord. He is also the district mission coordinator, SSA, my lord. He had requested the mission director to release or to issue a fresh, my lord, DIAS code, my lord, in favor of our school, my lord. It was never issued, neither it was, my lord, released, my lord. The earlier was also not released, my lord.
For provincialization,
It should have been issued, my lord.
for provincialization, we have to verify the data, UDAS data.
In fact, my lord, by virtue of,
Who is appearing for SSA? The Igogwe
After some time,
after some time.
I'll ask them.
Okay, after some time. Let SSA complete for the SSA.
Please, your lordship. Your lordship has heard the matter, my lord, and in last occasion on 14/5/2025, we have or your lordship has directed the yes, my lord. In 2-3 days, Mr. B. Kaushik is appearing in this case, my lord.
Earlier, okay.
Yes, my lord.
People pick it present.
And thereafter, my lord, one date also gone in between, my lord.
Pardon?
In between from 14/5, my lord,
after one date gone in that date, my lord, my learned friend has taken up time for taking the instruction, my lord. My lord, she has directed to take the instruction regarding the verifications by the District Elementary Education Officer Dorong regarding the ambiguity in the name, my lord, of the petitioner. And it is clearly stated in the order 1455, my lord, at paragraph 5, my lord.
So Bora, you are appearing.
My lord, here, my lord, my friend D. Kaushik is appearing. Today he could not present before this court, my lord, from due to some personal reasons. My lord, next week, any day,
On Monday, my lord, if
He
possible.
absent.
my lord, my friend is informed.
In that case, my lord, on Monday, if possible, my lord.
Okay. Or, MAI started. So PK Bora started. The next topic for the elementary department of E Kaushik. For the instance of the for the elementary part of the matter was the site. Commits that the big pair of
Obliged, highly obliged. Part method.
so then next week,
Next week, Monday, Tuesday, my lord, if possible.
3rd November.
part of
Highly obliged.
At number 3.
My lord, in this case, my lord, we have completed our part on the other day. My senior, Mr. N. Dor, my lord, he has completed our part, my lord. Now today, my lord, my learned friend will argue on the matter. My lord, if required, we shall file our reply, my lord. We shall give our.
Lordship, here in this matter, I am making a prayer on behalf of S. Das, Lordship. He was supposed to appear in this matter, Lordship. He is looking into this matter, Lordship, but due to some personal difficulty, he could not prepare the case today. So he has asked me to request that this matter may be listed on Tuesday, Lordship.
okay. But the not coming Tuesday,
2nd week of
Okay.
My lord, date may kindly be fixed, my lord. My lord, because my lord, the matter is
the
pending
the
these things long, my lord.
the report for that council that for the higher department. It's so that is better for the yes, the fair enough.
13th November.
Lordship, he is present, Lordship, but he could not prepare the case today, Lordship. Due to some personal difficulty, Lordship, he could not prepare the case today. He is otherwise present in the court. So he is asked,
Present in the
yes,
court.
yes, sir.
Then, my lord,
That's why,
he
Lordship,
can argue,
Tuesday-
he can argue on the second half, my lord, if possible, my lord, because matter is, my lord, long
Lordship,
pending,
he-
my lord,
he has not-
23 matter,
He
my
is
lord.
not prepared today. That's why. On Tuesday, that's why I paid.
But for one has it prepared the matter. They protect the they are ready. But if they are not ready, then what?
My lord, my lord, then, my lord, next Tuesday, my lord, part hard matter, my lord,
Next Tuesday, this court will not be sitting here.
I see, my lord. Then,
That's why November 2nd week.
November
13th.
13th November. My lord, endeavor may be made, my lord, to dispose of the
Definitely, I am
petition.
always ready.
My lord, my lord. Because issue is very simple, my lord, in this case, my lord. I have, your lordship has on the other day, my lord,
Coming then,
Yeah.
like,
my lord,
try to dispose of the same.
my lord. I am deeply obliged.
Highly obliged.
Done episode of all. That's the list of matter after one. event of subsequent non-representation of the petitioner to the court.
Item 11,
Lordship, kindly possible that for time being.
Time being,
item 12,
In this case, we have filed an IA for production of records. The standing calls have sought for time on several occasions. If there are no records, that IA may be closed. And if they are not insisting, my lord, otherwise I will argue on merit, my lord.
Talk with the department today, my lord, as because today is state holiday. I will
I will.
or it's a informal or
I will kindly
production that info component of the limited of the court. Focus. Subject said, it done it one time, and he could not produce the record. On account of today being declared as state holiday. If they develop this subject matter after.
That may be fixed, my lord.
on 31st October.
Yes.
Items 13 and 14,
I am for the respondent ONGC in both these matters. Contention of the writ petitioner is challenging the punishment of dismissal from service. Person was involved in some fraudulent activities. On the last occasion, I am for the respondent ONGC. Last occasion, my lord, the case had to be adjourned on the prayer of the writ petition. Earlier also, they had taken some more time.
Say the conflict is absent. Or none appeals for the petitioner also, however. This the matter after a week, the event of subsequent non-representation of the petitioner to state for the support.
My lord, can I have a date?
week. On, on 6th November. Item 15,
Lordship may take up this matter after some time, my lord. My senior will appear.
In Lordship, I have obtained the latest instructions and first to place the latest instructions here also.
Yes.
So the report has been sent to the secretary, your lordship. Can't. Yes.
State level committee has recommended the name of the
Lordship, the state level, yes, yes. No, the committee had held a meeting to decide on whether the appeal that was submitted by the president, by the then president, he had expired, your lordship. So whether that, what will happen to that appeal, your lordship? Because that appeal was filed against Jomil Ahmed against his provincialization. So the committee had to decide as to what will they do now, because the president had expired, your lordship. So now they had asked for a report from the school, your lordship, whether they have any difficulty in provincializing his service, whether the president and the managing committee has any issue. So now they have given it on a positive note that they do not have any issue, and if the services of the petitioner is provincialized. So now this report has been sent to the government, your lordship. So on that, they will decide now.
when this letter was sent.
It was sent yesterday, your lordship. It was forwarded yesterday.
No, where's what is it?
Lord. Okay.
Almost 98.
Lordship, 2 weeks, 15 days.
Part the book the part. It's part of the part. Second part. That according to the letter of the director, secretary part. Address the secretary of the staff. They did the second and the fight. And the essence of the same. So it's substantial. After obtaining a report with the school management committee, the director has forwarded the name of the petitioner to the government for taking a decision. And the process may take at least 15 days time and the right for the method after 15 days. Where the development
14th November.
the vendor for this that they mark that then take the correct.
Obliged.
Item 16,
May I please, your lordship, for item 13 and 14, Mr. B. Pukasta is on leave. So it may be listed after 29th, after 29 October. Any date may be
29 item number
13 and 14.
13 and 14.
Yes, sir.
13. It has been fixed on 6th of November.
Okay, yes. Okay, I am extremely sorry. I could not reach the from the code number 1. Item number 7 to 10.
Already that has been given.
If lordship convenient, can it be taken today or at 2 lordship? I beg to get item number 4. I have to attend there. That is why I could not reach.
It has already been fixed after 1 week.
Then I am not saying it. Kindly, if you fix it a short date, lordship.
Take it that for
item 16,
wait. What is the what? Yep. After some time, Mr. Sinha.
pending the, item 1,
It's a totally. You come to this page number 99 of the rate.
Yes, my lord.
That is the impugn order. The impugn order is based on a report that during the year 2016 and 17, no enrollment on due time in the database maintained by NOPA for the year 2016. Whether that report is available with
At this moment, Lordship, I do not have the report. I have to call from the office. Because it was submitted before the committee formed by the education department.
Yes. No, the entire impugn order is based on this report.
Yes, my lord.
So unless this report is available before this court, it will be difficult to take a decision.
One thing, Lordship, at page 96,
Yes.
Lordship, here it states that the district elementary education officer
Hmm.
at paragraph second, the deputy commissioner, Lordship,
Hmm.
has organized a hearing meeting of both the parties, checked the original document, etc., and issued a speaking order that the school headed by so and so is the original school with the dice code number so and so. The other school headed by Habib so and so is not original school. So the dice may be either renewed or issue a fresh dice code to the school headed by the petitioner. Lordship, for renewal purpose, he has to make an application giving all the details of the school, including the land document, number of students, and everything in a prescribed format before the authority, whether that he has given or not. If that he has given, Lordship, then authority are bound to renew it. If not given, Lordship, for the past year, no renewal can be done at this stage. Only fresh dice can be.
So now we have whether there was any enrollment in the year 2016.
Yes, my lord, but since it was suspended or discontinued due to a dispute between two parties, Lordship, whether after verification, when it was found that the petitioner school is the original school, whether because dice code has to be renewed every year. It doesn't continue for a particular maximum period of 5 years or 10. It has to be renewed every year because the ratio of the student teachers may vary each year for each class. So whether he has submitted that form, that clarification he ought to have given before.
No, that is a,
But
that is-
I will call for this report as Lordship has called for. Because this report was directly given to the commission headed by the formed by the education department. In that record also the report will be there, and Lordship, in all probability it will be also with the SSA authorities. I'll call for it. Lordship may allow me some time.
No, it might be available with you also. We will also find out that, but the original document is record.
My lord, from the communication itself, my lord, at page 96, my lord, it is almost clear, my lord, that since there was a dispute between two schools, and our school was found to
That
be,
is all right. There was. a
yes, my
dispute,
lord, that
but,
earlier, my lord,
ultimately-
dice code was blocked by the mission director, my lord. That has not been released, and the letter of request says, my lord, that it should be, otherwise, my lord, it should be released, my lord. Although he has stated that it should be, my lord, issued renewed or it should be issued afresh, my lord. But it indicates that it should be, my lord, renewed, my lord. That was never renewed to us, my lord. In fact, thereafter, my lord,
Lordship, he has to make an
continuously.
application
Please,
because
let
it's
me-
in the
Yes,
portal.
it's a part of record, my lord. I have made, my lord, continuously, and for the continuous, my lord, several years. I made application before the concerned authorities. There are several applications which are available also before your lordship, my lord. So those are the part of case records, my lord. In the file itself, those are there,
the Ahmad say
my lord.
this letter, this report is of dated it is not very good year.
Two thousand
The
seventeen.
year 2017,
Yes,
and this report was not considered by the director while passing the executive order.
yes, that was not considered well.
So the basis of executive order is
It should have been considered,
Uh,
my lord.
enrollment for the year 2016-17.
Yes.
If that letter is available for this court,
And regarding that enrollment position of the school, my lord,
yes,
I have already referred before your lordship, my lord, page 84, my lord. It says that there was enrollment in the school, sufficient number of students in the school. And the ratio is 30:1.
your report is not.
My lord, that was a, my lord, inspection report carried out by the, my lord, official authorities, my lord. Sub-inspector of schools, my lord. That
is
was never
part-
disputed by the respondent authorities, my lord.
That is report by part of.
Yes.
Mr. Prophet.
Lordship, 10 days time, Lordship.
That is fine. Better is better.
Long, my lord.
Because today, Lordship,
Holiday.
office is closed.
Part the day of part. The people could start it. That's it. Day for part. Part. Part getting perfect concept for both the parties because complex. But in order dated 28 April 2020 was passed by the Director Elementary Education Assam Hyderabad of part regarding enrollment in the school of the petitioner during the year of the 6-7. But the report not made available before part. According to the supporting part, the same concept of the part are directed to produce the same report before this court on 10th November. 10th of November.
Coming again? Yes. 7. My lord, in this case, I am appearing for the Food Corporation of India. My lord. It's a matter relating, so it's a matter concerning compulsory retirement. Therefore, my lord, I think we'll have to produce the records, my lord, as to how that satisfaction was derived, that he is a deadwood. So, my lord, otherwise pleadings are ready. So you can keep it on 11th or 12th, we'll produce the record. So perhaps it is our duty to produce the record.
Even in the pleadings, Lord, stand has been taken that based on the entire service
Profile.
profile, the decision has been taken, Lord. Since it's a surgery proceedings, Lord, record will be necessary, Lord.
Okay. Part Mr.
Only
Today,
thing
but
that short period may be given, Lord.
हाँ,
yes, so today part is
अगर तक हमको 11वां part ले लो.
comments that think the petitioner was compulsory retired the third step from 8/5/2026. Production of the entire record is necessary. Then
We'll produce the record which contains the reasons why the decision was taken.
with the file, concerned file to complete the return based on which the decision for compulsory retirement of the petitioner was taken. Then I press for the second matter on 11. 12. 12.
12. Deep left.
Fair enough.
Item number 74 orders.
Monday.
When the entire process will be complete?
After getting ex post facto approval from the finance department, he will get the other benefit, madam. So, my lord, may keep us some at least 3 weeks time, my lord.
Oh, whether the order for corrected it was passed.
No, recommendation was made, my lord. Because first SLC has to recommend the case of the petitioner. That has been done, my lord. Now order of regulation will be passed, my lord. Thereafter, that will be sent to the finance department for post facto approval. After getting the approval from the finance department, he will get the benefit, my lord. For the entire process, my lord, I am taking at least 3 weeks time, my lord.
The PU the judicial department was taken after approval by the SLC or before approval?
Before approval.
Before approval. So when the SLC has granted it
1710, my lord.
17. But
If, in 12 plot, 12 of November.
12 of November. Or the 8th of third. September what? During the course of deliberation, Satya has published the letter dated 22nd of October 2025 of the Secretary of the Department. And on the basis of said letter, that the name of the petitioner has been recommended by the subset L17 and now the each of the petitioner will be forwarded to the finance department for grant of post facto approval for retention of the section posting of that body. And he tries to listing the matter after 3 weeks. So as to enable the tender complete the entire process according to the sub provided that 12 the better for the mark B and check the correct.
Obliged.
Item 80.
This contemplation is for non-compliance of order dated lordship 26/9/2022 lordship. Page number lordship 9.
The other day, Mr. Corpusary has formed its court that one review petition.
Yeah, yes, lordship, but that did not appear in the review petition, lordship. Review petition listed on 4/8/2025, then 28, then 22, 29, 5 and 13/10. That did not appear, only taking time, lordship. There is no stay. Now, lordship, if your lordship kindly see the order dated lordship 18/3 lordship.
Let the Corpusary come
Lordship.
after some time, but
Lordship.
For the state level committee has
Already recommended the name of the petitioner. Thereafter, his name was placed before the joint committee. Now, joint committee on 13/10, my lord, they have directed the district authority to produce these communities letters, my lord, along the appointment, joining, working status and subject of by the petition. On next, to place before the next joint committee meeting.
Well, no, today they are supposed to produce the appointment letter. Now, 1.5 years has gone by, man. And there is a mandamus, my lord. The court has interfered there with the provincialization respondent number 6. So whether he is still continuing after his appointment has been set aside by this honorable court, respondent number 6 is not supposed to continue, my lord. And I has to be placed, I has to be put in my place, my lord. Because I have been deprived of by provincializing the service of the respondent number 6.
As per the
Yes,
new
my
act,
lord.
my lord, for
What they are doing, my lord?
Post-
1.5 years has gone by. Respondent number 6 appointment has been set aside by this honorable court. Lordship will may kindly see page 28, my lord. Page 26. Lordship may turn to page 26, my lord, paragraph 28. My lord, will see para 25, lordship, para 25, my lord, sorry, page 25. In view of the above position and the conclusion reached herein above with regard to the provincial service of respondent number 6, that in such provincialization of the service number 6 is hereby interfered with. And his provincial letter was set aside.
Well, as per the act, posts are personnel. Once personnel is gotten, do you have to create a new post? That is why it is taking time. After recommendation of the joint committee, my lord, after verification.
if the SLC has recommended, then why the joint committee?
And they have to comply to it in 3 months.
Because we cannot replace another person against a person, my lord. But against him, my lord.
And he cannot continue, my lord. My submission is respondent number 6 cannot continue once the provincialization has been interfered with.
We have to.
And if the department has allowed him to continue, that is a contempt also. That is also contempt also. No, and why
Allowed
not?
to continue, my lord. We
Yes.
have to create a post in the name of the petition, along with the sanction of the finance. That is why it is taking time, my lord. After joint committee approval, my lord, the process will be in.
In which post the respondent number 6 was?
Respondent in the, my lord, in the language teacher, my lord. There 2 language teachers have been appointed, my lord. As per 2017 Act, my lord, there should be 3 teachers. One from the science, one from language, one from social science.
The appointment of respondent number 6 set aside by this court. Then in that post, you have to appoint the petitioner.
No, we cannot, my lord. We have to create a new post, my lord. Once these posts are personal as per the act, my lord.
As per the,
Act, my lord, these posts are personal. Once person goes, post is.
no,
His
But
appointment is
that-
set aside.
an initial recommendation against the language teacher.
He cannot continue.
That is why we have abolished one language post.
And they have to do it within a period of 3 months, my lord, from the date of the order. That is also a direction.
After 2 weeks, my lord.
not to it, so why the respondent number 6 is still
As per my information, no, my-
Let him up then.
no, my lord. I will take instruction regarding, I will confirm.
what is your response?
Continue watching there. Let him obtain instruction, my lord. It will be respondent number 6, my lord.
Well, I'll.
Because I am not in the circuit till date. Because of that, my lord. And not only this, my lord, if your lordship kindly look into para 31 also, my lord, page 37, lordship may kindly see. That is the conclusion. My service should be provincialized from 1/1/21 with all consequential benefits. So nothing has been done till date. And lordship
Process is going on, my lord. We are processing.
last occasion, my lord has directed them to produce the appointment letter. And they're producing one letter after another, doing this, doing that.
the Bora,
my lord.
whether it is order dated 25/9/2025 was communicated direct.
My lord.
Yes.
My lord.
Then why the director has doing it?
My lord,
Director,
joint committee meeting was held on 13/10, as per this, 13/10,
Where it is?
my lord,
13.
this, with reference to the subject, I like to state that as per the decision of the joint committee minus dated 13/10/2025, you are requested to furnish the detailed report along with appointment, joining, working status and subject sought by the petitioner as well as the respondent, namely, as I got along with the education concern based on school record and dice data along with relevant.
It is as per
supporting
number
document.
6, not me.
Both the director asking from the district manager for both respondent six as well as the petitioner. Ma'am. To placing before the next joint committee in connection contempt case number so this is so district element Bongaigaon before 29/10/2025.
Why did the status report is required in respect of respondent number 6?
Well, regarding the process when the name was
If the appointment of the respondent number 6 has already been satisfied by
My
the
lord.
court,
my lord.
what is the question of
Yes.
taking record?
Yes.
by court?
Well, regarding this, I'll take it. That's why this
That the director is that
Yes, my lord. Then the matter will be solved, my lord.
29/10, my lord, next joint committee is there. They have got district authority has directed to place provide the required information before 29/10, my lord.
part, sir, it takes up started. The Bora, started, Bora is part of the tender. This is 22nd of October 25. Written by the director to the secretary. Once. Seeking detailed report along upon the subject of the as well as by the ISAC best record and the supporting of and I think the next joint of the content you the one of one under the ticket limited point on or before 29. And the bit of the Bora has what I think of the Alba. The post started on conscious of the order. It passed by court on the 6th of September 2025, where the contempt norm was where the Bora was directed to produce the appointment letter of the court. And under such circumstances, to direct the director it appears from the order dated 25 that the Bora was directed to produce the court today. But the Bora has tried to produce the report the letter dated October 20. And result of the state letter indicates that apart from seeking information regarding appointment, director has also performed the working setup and subject taught by the respondent number 6, along with education and qualification. Based on this record and answer. But it appears that the appointment of the respondent number 6 has already prepared by this court. Above, it appears, above, the exercise being carried out by the contender appears to be clear. And under such circumstances, the Bora Garnet contender is given another son to produce the appointment letter of the petitioner for this court on part of
On 10 November.
In the event of failing to produce the letter for appointment letter for on that day, the director shall remain present personally before this court. Letter produced for market. Then take the time.
Oblige, Lordship.
Item for hearing. Started.
But before
पता है आपको वही पता है तो ये देखिए
now the standing counsel for the education department has filed a affidavit.
Lots.
You have received a copy.
Yes, and I have also filed a reply.
Reply.
In both the cases,
Both the
these pleadings are
pleadings are complete, Lord.
Arguments also completed.
Argument, Lordship has heard,
Heard,
I
my
will
lord,
just
no.
refresh.
to the extent of the petitioner, my lord. And to the extent of the other side also that was heard in last occasion, but last occasion, my lord, I was on VC, so there is some technical fault for that, my lord, it took time, so that is the again matter was listed again.
Supposed to appear, my lord. He's on like court number 7, my
Let him
Yes.
talk.
Space court Tuesday, my lord.
Pardon?
I have,
You-
No.
I have seen him in the court.
He is always there, my lord, if you comment is always there, the moment, my lord, the case is called up, my lord, he is always going to disappear. This is
Let him, let Mr. Upamanya talk.
My lord.
For 1 year, last 1 year, he has taken. a-
Yes, my lord.
Yes.
I'm just saying on behalf,
Ask him to remain present.
my lord.
Your Lordship has already heard the matter in part. I have been kept my service, so I was not allowed to join in service where I was having the appointment letter. And even after the instructions of the Assistant Labor Commissioner Dibrugarh, they kept my service in abeyance only under the plea that there can be some hesitation by the labor union. But there was not a single document produced by them showing the apprehension.
You have completed your part of argument.
Yes, your lordship, pleadings are completed and the matter has already been heard in part, your lordship.
Yeah.
Yes, yes,
Your part is completed.
my part is completed.
But if I am representing the management, respondent number 6 and 8. I want to kindly come to the order dated 22/4/2024 and thereafter 3/5/2024, where this honorable court has placed the matter regarding the maintainability of the case, because the school is not provincialized school. So this petition not maintainable.
Order dated
22/4/2024 as well as 3/5/2024, two orders. And 3/5/2000 which is placed, and on the basis of which the Elementary Education Board has submitted their affidavit. (22/4/2024). Stated non-native for the petition form. PK Bora landed suspended on elementary education department has placed on record the instruction received from by him from the Director Elementary Education Assam, which reveals that the school of the petitioner was provincial by order dated so and so. However, it is contended in the said instruction that the petitioner he is not entitled for being considered for provincialization of his service as he was not working as a Shiksha Karmi under the particular scheme, not a teacher of the said school. However, in absence of counsel with the petitioner, this court would not like to further consider the issue today. Actually, this leaves the matter again on 3/5/2025. Copies of the communication dated so and so and notification dated so and so are as produced by the Board and the State Council Elementary Education. The department is kept on record, marked as X and Y. Then subsequent order dated Lordship
So,
is 3/5.
Papa,
Yes,
it order dated 3/5/2024.
22/4/2024. 22/4/2024. First order is 22/4/2024. Honorable Justice N. Unnikrishnan.
Your Lordship, on the part of Your
Pardon?
Lordship, regarding the allegation that I was only a Shiksha Karmi, I have clarified the matter in my affidavit in reply filed on 28/6/2024 that it was an additional service rendered to me in addition of my service as an assistant teacher in the school. I was not entirely primarily as a Shiksha Karmi. That was an additional service given to me.
With the record.
Your Lordship, that is, there has been an agreement and that agreement has also been annexed in the affidavit in reply. That is page number 61. Page number 58, Your Lordship. Annexer C. And I have
Page
also
number
annexed my,
58, Annexer C.
yes, Your Lordship, in my affidavit in reply, that is filed on 28/6/2024.
Yes, Papa, I have to fix this, Annexer C. So, the school appears to be a provincial school.
That has come. You see, it comes to the affidavit by the,
No, first you come to this Annexer C.
yes, Lordship.
That is a report given by the Block Elementary Education Center.
The school run by the management is not provincialized. And as such, on 3/5 or 2025,
Not-
for,
You come to this Annexer C.
yes, Lordship, that here name is to be shown. I have also obtained the certificate copy that I have affidavit file. They have also restored. That said that only 2 teachers. Only 2 teachers are provided whom the government is paid the salary. And the school is everything run by that. That is affidavit in my affidavit is here also. I'm placing.
Why should we disbelieve this Annexer C?
The document is there, the school is not provincialized. Management school is not provincialized. The authenticate document has also been. This is elaborate part is given and instruction was to be directed to furnish affidavit to the opposition to the elementary. They have also submitted that the school is, that is their affidavit is clear in a flag K, paragraph number 3. You also submit they have not submitted copy affidavit for elementary education certificate. They have not submitted the copy. So 3/5/2024, your Honorable Court has passed the order that as several learning petition, so the petition would now be required to also to satisfy this court whether present situation being with regard to grievances raised against the tea garden measure would be maintainable. Because only 2 teachers, that document I have also enclosed. Then affidavit was filed by
Yes,
affidavit.
when the elementary education department has filed the affidavit,
9/6/2025.
82.
Flag K, you know. Last 9/6/2025, flag K. Page number 99 to 103. And paragraph 3 is clear to that document. Flag K in the last. Paragraph number 3.
The next is case number 87. Next is
So where is the list? List of this 419 numbers of people. Page number? Yes.
Minute.
So if you tell me if the school is provincialized, why the petition should not be maintained? Now the school is under the government. So why this is a petition which not be maintainable? No. Oh, that's all right. If the school is already provincialized, so why this petition would not be maintained? Maybe. No, if the school is maintainable, no, sorry, if the school is already provincialized, that is, petition is maintainable. We will see whether she will entitled to be provincialized or not, but the school is
No.
already provincial. But then why does a writ petition not be? Pardon?
Your Lordship, at the time of the petition, the
Okay,
school
wait, let her complete. Yes. At that point of time, the school was not provincial. When this order was passed, 1/6/2018. So it was provincialized in the year 2023.
Lordship also. Then they see the flag
And-
F, the affidavit is filed by reply class on 23, flag F. There also the page number 64, flag F by the student of state file. When they place one document before the regarding the provincialized, then documents again was obtained within Actor C. Thereafter, this court has the order 3/5/2024 regarding the maintainability. That is page number 64. Look. Got to page number 64. Flag F 28/3/2024. Useful. So many affidavit reply were filed one after another. This is a flag F.
Yeah, right. 26.
Madam Sorma, you have selected the order dated 1/6/2018. And when this implicit order was passed, the school was not provincial.
Yes,
Then whether this petition is maintained.
Your Lordship, there was a government memorandum and which was seeking applications from the teachers of the venture schools to submit for provincialization of their services and for consideration before the district scrutiny committee. But as my service was kept in abeyance, I was not able to avail that opportunity given by the government. Your Lordship, that memorandum I have annexed in my main petition. Annexer Annexure 5, Your Lordship. Annexure 5 and Annexure 6. As my services was kept in abeyance without giving me any notice and opportunity of being heard, I was not able to avail this opportunity given by the government.
That's okay, but at that time the school was not provincialized. It was managed by the tea garden.
But it was
property.
a venture school, Your Lordship. But it was a venture school. And only venture schools are eligible for the purpose of provincialization.
Vera? Paragraph number? Yes. It's a matter after bit for further hearing. Part. Pardon. That's the number go for
6 and 8. 6 and 8.
that. For the number 20. What 20? It's more of 5 and 7. 13 parts, 6 meter.
Lordship,
November.
Lordship, kindly a date may be given. A date may be given.
30. Yes.
Sir, in this matter, the learned trial court has outrightly dismissed my counterclaim regarding adverse possession, along with the dismissal of the main suit on the application filed by the appellant defendant number 4 and 5 in the present suit, thereby stating that the counterclaim is also barred under section 69 of Partnership Act. And the defendant counterclaimants have stated in their pleadings that the firm is an unregistered one. That being so, their claim is barred under section 69 of Partnership Act. And the reliefs emanating out of a contract of the partnership. However, in the present scenario, the section 69 of Partnership Act is not applicable in the present counterclaim and in the present scenario and the facts and the circumstances of the case. As I have claimed adverse possession, I have not mentioned that I am the partner of the unregistered firm. Rather, I have taken defense in my written statement, thereby filing a separate counterclaim in the above mentioned suit filed by the respondent, and taking the plea and filed the application under Order 7 and D to dismiss the suit as per the section 69 of the Partnership Act. Kindly see the title of the main suit filed by the respondent. That is on the page number 1. It has specifically mentioned in the title of the suit that the defendant number 4, defendant number 5, defendant number 4 is the legal heir of late Rukmani Devi Singh, who was the earlier partner in the partnership firm with the respondent. And secondly, kindly see page number 5, para number 4, which also clearly states that the plaintiff, along with the Rukmani Devi Singh, wife of late Bhuvanpati Singh, the predecessor of the defendant number 1 to 5, herein had jointly constituted a partnership firm.
No,
On-
whether the flight is part of this appeal.
Yes, sir.
Page number.
Not on, it is the main
Or for
suit,
record.
main suit filed by the respondent.
You have not exposed the flight which is appeal.
I have filed separate counterclaim and I have filed along with my present appeal. However, I am mentioning the paras of the main suit filed by the respondent, who was the plaintiff in the main suit.
So the next are is your counterclaim.
B is only my counterclaim. And as per the TCR, which has been called by the Honorable Court, the suit of the respondent, who was the plaintiff in the main suit, I am mentioning those paras regarding the admissions made by the respondent. In the title itself, it has been mentioned that on the death of the late Rukmani Singh and late Bhuvanpati Singh, their legal hire. First of all, and secondly, on page number 5, para number 4, the plaintiff has averred that the plaintiff along with late Rukmani Devi Singh, wife of late Bhuvanpati Singh, predecessor of the defendant number 125, had jointly constituted a partnership firm on 19th of July 1978. I was not the partner in that unregistered partnership firm, nor any agreement has been entered by the respondent with the present appellants, that is defendant number 4 and 5. And out of the said partnership firm, in the same para, respective properties has been purchased, that is mentioned as Schedule A, Schedule B, and Schedule C. However, I am claiming my adverse position regarding only two properties, that is Schedule A and Schedule B. And on page number 8, para 8, the plaintiff, that is the present respondent, has mentioned in her suit that most unfortunately, it is mentioned herein that the year 1992, one of the partners of Messrs. Firoz and Co., namely Rukmani Devi Singh, that is the other partner, died. And on her death, the defendant number 125 agreed to continue with the said partnership. But no partnership agreement has been filed with, that has been executed between the defendant number 4 and 5 and the present respondent. And as per the death of the earlier partner, the partnership firm has automatically been dissolved. And kindly see, lastly, the prayer on page number 22, prayed by the respondent, that declaration that the plaintiff is one of the, now the respondent is claiming to be the existing partner of the Messrs. Firoz and Co., having half share in scheduled property A, B, and C. Secondly, declaration that the said deed of retirement and MOU to be null and void, all the proceedings to be null and void. If one of the partners has already been died in the year 1992 and no new agreement has been executed in between the present appellants and the respondent, who is the plaintiff in the main suit, how can section 69 of partnership can be applied to the
Date of partnership is part of the record.
the partnership?
Yeah.
Is not, the earlier partnership was also not on record. It was an oral partnership agreement. No partnership agreement has been filed. However,
See, to appreciate your topic, we have to go to the partnership date.
but the respondent has filed the documents, that is the registered sale deeds of the properties mentioned in Schedule A.
You show me the partnership date.
Yes, sir.
Show me the partnership date.
The properties were purchased in the name of the firm of partnership, specifically mentioning the name of the partner. It has been annexed with the suit filed by the respondent.
Where is that date?
Page number page number 38 of the main suit. In the last line, shall mean and include the said vendor, their year, successors, executor,
Page
administrator.
number 30.
Page number 38. That is the document number 2.
The record of the trial court.
Yes, it is in the record of the trial court. It has been filed along with the main. It has been it's not available in record. However, I applied for the certified copies. These are the certified copies supplied to me, and it has also been mentioned in the main suit, which is on the record of the trial court, that Schedule A and Schedule B, herein below, which are subject to the plot hearing. Document 2 and 3, it has been mentioned in the main. It has been supplied to me also. I am having the certified copies.
Okay, then you bring the same on record by way of an affidavit.
I'll
And
file it.
also file that partnership deed,
Yes, sir.
partnership deed.
It was earlier partnership deed. It was in the under the take care and possession of the respondent itself. That's why they have filed to execute that in continuance of the old sale deed. They are to be declared as one of the existing partners in the firm which has been dissolved much earlier in the year
Yeah,
19.
Is it with you?
No. The document. I'm having.
Then how we will decide the epi- Have you heard something? Whatever be it registered or unregistered, you produce it. Heard Mr. Sharma, heard it, heard of it. I'm also heard that EMSA, A Cabra. Heard it. Heard in part, please comment there. After. It is
Highly obliged.
27.
May I please your lordship?
Yes.
In this matter, we have applied for the copy of Gopur Thana and Sessions Court. On 24/6/2025, I have this application with money receipt. But till date, they have not supplied to us
Oh,
from the registry, the copy section, certified copy.
that means today also you are not.
That is why I am not in a
submitted.
position, because that is why I obtained this. We have applied on 24/6/2025. And we are making follow-up, but still we are not getting. Though it is a voluminous, there are 4 bundles A, B, C, but it is almost 4 weeks, 4 months.
You furnish a copy to the court master, we will acquire from the section why it was not furnished.
Okay.
Then we will give the date the second half.
Otherwise also, we are not in a position to conduct the case today because copy is not with me. Some other date may
Oh.
kindly be given, I will
No,
submit.
that's all right. We will give the date the second half, not now. We will acquire from the section why it was not furnished. And the last part of November. So
Much up.
fix the date later on, not now. First we will acquire from the section. Wait.
Much up.
You furnish a copy to the court master.
Item 28.
Hello, the matter pertaining to the release of area salary, my lord. My lord, on the last occasion, my lord has directed us to submit the judgment of passed by this honorable court. My lord, we have already submitted before lordship.
Regarding area salary.
Yes, my lord. My lord, one writ appeal number 301 of 2012. State of Assam versus Orunima Chetia.
order dated 18/3/2015. Para 9, my lord. Upon hearing the rival contention and after going through the order of the learned single judge in question, it is an admitted fact that all the respondents in the appeals are continuously working as teachers and their salaries are being paid by virtue of the court orders. Arrears of salary from July 2007 are not being paid. When the respondents are continuously serving as teachers, question whether they are illegally appointed or otherwise is matterless. However, for the services rendered by the private respondents and availed by the state on the principle of quantum merit, the salaries have to be paid. In that view of the matter, we find no ground to interfere in the order of the learned single judge. Accordingly, the appeals are dismissed. My lord, then another one, my lord, repetition number 5286 of 2004. Judgment dated, my lord, 10/3/2011. Fact of the case herein, my lord, similar to the present writ petitioner, my lord. My lord, at para 5, my lord, of this judgment, my lord. In the regularization order, it was recorded that the appointees would receive their current salaries with effect from 1st of August 2000. And in the consequential order of regularization issued by the District Elementary Education Officer DEO Kamrup, an undertaking was obtained from each beneficiary that they will not claim area salaries for the past service, which would, however, be counted for pensionary benefit. Then, my lord, paragraph 11. When the government secured such undertaking, the teachers were desperate and were serving without salaries, which was stopped with effect from May 1995. They were also anxious to have their services regularized. In such backdrop, when the state offered to regularize the services of the teachers with a precondition that they will not claim their area salaries, the teachers were hardly in a position to bargain and resist giving the undertaking to the state, as they were on the back foot and were not on equal bargaining position. Then, my lord, paragraph 12. But in this context of the unequal bargaining power of the state vis-a-vis the teachers who were desperate for salaries and regularization, the clause incorporated by the state for unequal bargaining power is nothing but an unconsciously convenient forced by the state on a group who hardly had any stand to resist the might of the state. In fact, the petitioner had practically no choice in the matter and had to relinquish their claim for area salary, despite rendering service for long years. This type of covenant can be said to be a right or reasonable and amounts to be uncontestable contact as held by the apex court. Paragraph 14, my lord. In view of above and considering the law laid down by the apex court in Sukhdev Pandey Supra and this court's decision in the case of State Land Use Board Casual Employees Association Supra, I declare that the petitioners are entitled to their area salaries from their respective dates of appointment. 15, my lord, having held thus, the court must also note that the regular vacancy budgetary provisions are unlikely to be available to make payment of the area salaries for the concerned period prior to 1st of August 2000, and the state may have to take special measures like creation of supernumerary posts and special allocation in order to make payment of the area salaries. Accordingly, it is ordered that necessary exercise for payment of area salaries be made by the respondents authorities expeditiously and preferably within 6 months from the date of receipt of a copy of this court order. Fact of the case in this judgment similar to the present writ petitioner, and now the petitioner is serving as a tutor as per the new appointment order, my lord, on 30th January 2021 with effect from 1st of November 2020. With effect from? My lord? With effect from? With effect from 1st of November 2020. And he's working as a fixed pay as tutor, my lord, in the same school, my lord. That is Bhurkushi Srimanta Sankartet LP School at the amount of 10,500. No, no, it took subsequent appointment. Yeah. Subsequent here.
Oh, may I submit, my lord? Regarding this case, my lord, with regard to appointment of 99, now there are many illegal teachers been appointed. Now, the government of Assam has come up with a policy with regard to this. And so they have been appointed on fixed pay. Now, this fixed pay they have produced with regard to this order that he has been in fixed pay, but this has not been got on record by way of an affidavit. Let it be got on record because there are many cases wherein earlier they were working, my lord, but they were found illegal and subsequently contempt case were filed. And so the government took a holistic decision and thereafter decided to appoint them on fixed pay, altogether a different policy. And they have accepted that they will not claim the area salary. And that has been the crux of the matter. Unless they bring this on record, my lord, it is difficult for us, my lord, to take into account.
It's not part of the record. No.
Let them bring
But
it
on the last occasion, during hearing, my lord, I have submitted before your lordship this order, my lord. And before the standing council also elementary. Yes, my lord. So my lord,
area salary. So this is because of the undertaking, this become infructuous by the other one. Let them bring on record. We can also reply to that. They are not bringing on record because of the fact that they have given an undertaking to that effect. I don't know whether he have given the undertaking or not, but there is an undertaking that they will not claim the area salary by that because their appointment itself was illegal.
my lord, in the order itself, it is reflected. My lord. It is new
Order itself
appointment.
is reflected. Let it come on affidavit, my lord.
No, whether affidavit will be required.
Yes, my lord, because we have a right to reply to the
Order. My lord, there's appointment order, new appointment order dated 31/2021. I have already submitted before your lordship. Is it part of the record? Not part
No.
of the record.
that is subsequent.
Then bring record.
Yes.
Subject by filing.
Affidavit please, আমাকে
Or
একটা copy.
Sir D.K. Roy, Colonel Court of it. And Sir D.K. Moya, Colonel Contact of
For
BTC.
BTC, respondent.
The PK Bora for the number. Sir D.K. Roy, Colonel Counsel for the courts of act. That's produced on the letter given to the petitioner. The pointing the petitioner by the respondent as tutor on a fixed pay at the rate of rupees 10,500 with effect from 1/7. And he has also sent one undertaking person to the said appointment letter. And they also submit that the said appointment letter is not part of the record. Then we will take the same on record by filing an additional affidavit where is accordingly allowed this the method on 28th of November. In the meantime, Sir Roy filed his additional affidavit. Yes, ma'am. Record the appointment letter. My lord, Madam Advocate is a part of yes, this is the matter as a part of
Deeply okay. Okay.
Is it lordship? Lordship, I'm appearing on behalf of Mr. K. Gogoi. He has some personal difficulty today, my lord. So matter
Pardon?
Mr. K. Gogoi has some personal difficulty today. So matter may be taken up, matter may be adjourned for the day, my lord. It may be taken up after 18, any day.
After?
18.
Or the care of or that.
Data.
Theater. Okay. Correct. Okay. That's that. Say. And press for the method after 18th of
Yes,
of
the web.
wherever this of the subject. But if it's covered.
Obliged.
If you have-
Yes.
My lord, I'm appearing on behalf of CAP1. We're fighting response number 1, affidavit second today.
The file affidavit today.
Yes.
Is it already filed or you will be filing today?
Will be filed.
Already filed.
No, will be filing.
Will be filed. Okay. Second.
Your,
18th of November.
Your Honor, it is already, I mean, there are no inferring, and they are not even giving me any document. Even I filed RTI, they refused RTI. I have filed for appeal. So matter is going and students are suffering and students' future will be in dark, Lordship. Because whatever classes are going on as on today, it is as per CAR, Civil Aviation Requirement, this is not valid. So students are suffering, also I
No,
am
but,
suffering, I'm in a
other day,
rented house.
It's the offer on the other day, you have insisted filing of affidavit by the director.
Respondent number 1, Lordship.
They, you are.
It is 1 month, more than 1 month.
Yesterday only I have received the affidavit, and that was sent for waiting, your lordship. Yesterday received, today I am filing, almost everything is over here.
It is 1
Short
month,
date may be
Lordship.
given, your lordship, short date may be given.
Okay.
At 2 o'clock, I will go through that affidavit. I'm sure I will not be having any
He
say
has
on
not,
that affidavit.
He has not yet filed it.
It is more than 1 month, Lordship.
Well, okay. That 4th of November.
4 November.
Or is that because of because of or that- if- So what Sabit said yesterday is the affidavit of the director. And it will file the date during the course of the day. According to it is provided that it's a matter of 4th of November. 4th November.
Deeply offended.
At 2 o'clock,
Okay.
at 2 o'clock, Lordship. Deeply obliged.
Timing matter 18 for admission.
Hello.
My lord, order is at page
Formally,
9. Lord.
what is the outcome of the petition?
Yes, my lord, it is at the very initial stage, my lord. It was listed on 3 occasions, my lord, but it could not reach, my lord. On one occasion, it was listed, my lord, and Honorable Mr. Justice Manish Chaudhary had heard in on some part, my lord, and he said, my lord, he will do the further hearing, my lord, on the next day. And my lord, on last, my lord, the review petition was listed on, my lord, 13th of October. And the review petition is, my lord, review petition number 179 of 2025. That was listed, my lord, on last 13th of this month, my lord. And it was directed, my lord, that it would be listed after 1 week. Thereafter, it has not been listed, my lord. And my lord, it will be listed very soon, my lord. Probably, my lord, in the coming week, my lord. Because the court is taking an interest. Because why, my lord? My lord, the order passed by the writ court, which is now put in contempt by the petitioner. In that order, my lord, the learned standing counsel for the revenue department who had appeared at that time, and my lord, the learned government advocate, they had considered, my lord, to the prayers made by the writ petitioner, that, my lord, the matter is covered by similar orders passed by this honorable court in some earlier writ petitioner. That is how, my lord, the matter was considered to, my lord, by the learned standing counsel as well as, my lord, by the government advocate. Thereafter, my lord, the matter revolved, my lord, and my lord, nonetheless, my lord, when the writ court has disposed of the writ petition, thereby, my lord, directing the authorities to count the service as well as, my lord, to do the needful, my lord, for giving ex post facto confirmation. Thereafter, my lord, the department has taken all steps, my lord, and to give ex post facto, my lord, confirmation for the service of the petitioner, in order to enable the petitioner, my lord, to receive the PCRG and other retirement benefits. But, my lord, the difficulty has arisen, my lord. The finance department is not giving approval. And, my lord, it is on the advice and the instructions issued by the finance department, my lord, that now, my lord, the revenue department has filed a review petition. And the difficulty here, lordship, is that, my lord, in the writ proceedings, my lord, the finance department was not arrayed as a party respondent. That is the difficulty. And all these facts, my lord, has been stated, my lord, in the detailed affidavit, my lord, filed by us, my lord. That is the respondent number 2. Now, my lord, the respondent number 2.
So like now you tell me when we will reach the matter.
My lord, next week, perhaps, my lord, that review will be coming up. And at the first day, it said, my lord, the court will decide whether, my lord, review can be entertained or not. Now it is on the issue of maintainability, my lord. That must, my lord. Okay. So if I may say, my
May I
lord,
please, Lordship? Lordship, kindly see, Lordship, in the review petition, Lordship, on 4/8/2025, review petition listed before the Honorable Justice Manish Chaudhary, Lordship. Then time was taken, no notice was issued. I am, Lordship, one of the respondent, Lordship. Now my learned friend, senior friend, Lordship, submit that, Lordship, under consideration, Lordship, for the hearing. On 13, last listed on 13/10/2025, Lordship, none has appeared.
no, my
The
lord.
order is reflected, Lordship, kindly see.
So, my lord,
Review petition 179 of 2025, sir. No notice was issued, Lordship.
Review petition is not before this court, therefore.
no,
Therefore,
my lord,
Lordship,
we have,
Oh,
my
can
lord,
you
wait.
vote
at
on-
least, Lordship, there are 5 occasions, Lordship, review petition listed, Lordship. Now, please, Lordship, the finance is not approved, Lordship. Kindly see, Lordship, 18/3/2024. The contempt order dated 18/3/2024 in contempt petition, Lordship.
Yes.
Kindly see, Lordship.
Yes.
Heard Mr. So-and-so learned counsel for petitioner, Mr. B. Bot Pujari, learned counsel appearing for the sole respondent, submit that the view of the finance department has been received and a respondent is taking up steps for implementation of the direction passed by this honorable court.
Yes.
Lordship. Finance department, Lordship, received, Lordship, view. Then, Lordship, 19/4, Lordship, again, Lordship, for compliance, Lordship. Then, Lordship, kindly say, Lordship, 3/3, okay, Lordship, then, Lordship, 19/3, Lordship, kindly say 25, or last order, 19/3/25, not last order, Lordship. in spite of the time granted, the direction contained in the order dated so and so has not been complied with,
So, Mr. Palakar,
Lordship.
if the, unless the review petition is disposed of,
Lordship.
we cannot go ahead with this document.
Now, Lordship, no notice was issued, there is no stay. Still, Lordship, 4/8/2025, no notice was issued. I am the writ petitioner. Review is, Lordship, against the order passed by this court.
Therefore, my lord, he did not spend so much, my lord. I am not agitating against him. What I am fairly submitting is that, my lord, the report, because whom, my lord, we have required the review. Instead of, my lord, straight away, my lord, staying the operation of this order, and, my lord, issuing notice, as, my lord, is hearing the matter on the maintainability of the review itself. I will have to satisfy, my lord, the court, review court, that this review is maintainable. If I do not satisfy, my review will be dismissed, my lord. That much fairly, my lord, I am submitting, my lord. That much
Or-
fairly, my lord. What
Malakar,
more
or-
can I submit, my lord?
That's corporate. That's content. Or the corporate is not that the review petition number 175
My lord.
get disposed of. And the matter may be listed by committee. And after 2 weeks,
My lord.
fair about this, the matter on
14 November.
Lordship.
14 November, my lord, on which date, my lord, I will apprise this honorable court, my lord, contempt court, my lord, with the outcome of the review. That my
on
lord,
that,
whatever,
the corporate shall apprise court about the outcome of the
my lord. I'm so obliged, my lord. Timing item 22 and 23.
Apology, Your Lordship, I was not there. when the matter was called, Lordship.
Pardon?
Apology, Lordship, I was not there when the matter was called.
No, it's the Upamanya, you see, this method is altered for quite a long time.
Yes, Lordship.
It is pending only for your argument. Complete your argument.
Yes, sir.
We will continue for 15 minutes. Thereafter, we will continue discussion. At 2 o'clock. Now you continue.
Lordship is taking this matter up. Item,
Item 22.
oh, he does, sir. Lordship, here we have filed our additional affidavit, Lordship. And Lordship, our stand is, Lordship, the UGC guideline, Lordship, which is the minimum requirement for appointment of Lordship lecturers, Lordship. It is, Lordship, MPhil and PhD. Sorry, Lordship, and net flat or PhD, Lordship. Here the petitioners, Lordship, they got appointed, Lordship, they got, let me have one. Lordship, here the petitioner, Lordship, he was appointed in the year, Lordship, 1985 in the Department of Hindi, Lordship, of Lordship, the ATP Nagaon College, Lordship. And Lordship, thereafter, Lordship, his service was regularized in the year 1993, Lordship, which, Lordship, is
Appointed in the year
1985, Lordship, in the Department of Hindi.
1985.
Yes, Lordship, as lecturers in ATP College, Nagaon, Lordship. Thereafter, Lordship, there was a direction of this honorable court, Lordship. It was by order dated 6/1/1993, passed in Civil Rule 304 of 1988. And Lordship, subsequent, Lordship, he was appointed in the year, Lordship, his services were regularized in the year 1993, Lordship, 12/11/1993. Lordship, that while his service was regularized, Lordship, there were, Lordship, few conditions were imposed. Lordship, may I read the conditions, Lordship? The first condition was that Mr. Ohidus is,
Page number.
Lordship, page number 60, Lordship.
Annexure number,
Lordship, I have noted down the conditions, Lordship, in my affidavit in opposition, Lordship. Opposition page
Is it,
60.
your
Otherwise,
affidavit
Lordship, it is there in page 22 of the writ petition, Lordship. Page 22 of the writ petition, annexure 2. The order of 12/11/1993 is there, Lordship. Lordship,
annexure 2.
yes, Lordship.
Yeah.
Type copy, Lordship. The condition number 1 was, Lordship, Mr. Ohidus Zaman is allowed to draw the fixed UGC scale of pay of rupees 2,200 to 4,000 PM plus other allowances as admissible under rules and procedures. Number 2, Ohidus Zaman will have to obtain MPhil or PhD degree within 8 years from the date of approval of his appointment. And number 3 was Ohidus Zaman will not be eligible to draw senior scale of pay, grade scale of pay until fulfills the condition laid down in the letter. Lordship, here in this matter, Lordship, though this was of Lordship 1993, Lordship, he has obtained his Lordship PhD from Lordship. Lordship, that PhD degree has not been annexed here, Lordship. I have not seen, Lordship. But Lordship, he has done his PhD in the he has completed it on Lordship September of 2010. Thereafter, Lordship, August 2009. Yes, Lordship, it was 2009, but Lordship, he was granted the UGC scale from Lordship September 2010. No, August 2009. But anyway, Lordship, this was beyond the prescribed period of 8 years, Lordship. Lordship, he was supposed to complete it within Lordship 8 years, Lordship, which he has not done, Lordship. It was in the year 1993 that regularization order was there, Lordship. He should have done it by 2001, Lordship, but he has not done it. He has done it in the year 2009 or 10, Lordship. The Lordship condition of
What is the prescribed period?
8 years, Lordship,
8 years.
as per the condition number 2. And Lordship, strangely, Lordship, in the prayer of this writ petition, he has not challenged those conditions also, Lordship. I have seen the prayer, Lordship. So he has
No, you tell me on what basis these conditions have been imposed? Is it provided in the UGC regulation
yes, Lordship. 1991 regulation is there, Lordship.
1981,
1991, Lordship.
91? The regulation part of the record.
Yes, Lordship.
Page number,
Page number, Lordship, 82, Lordship, of my additional affidavit. It starts from, Lordship, page number 79, Lordship. But Lordship, the lecturer part comes at page 82, Lordship. 3A, Lordship, the heading lecturer, Lordship. Page,
paragraph number,
Lordship, I have annexed the 1991 regulation, Lordship. It starts from page 79, Lordship, annexure A of my
that your best and the best. The basic order.
79.
Yes.
Oh.
Is it
Page 82. It starts from 79 and Lordship, the criteria is page 82.
notification,
Yes, Lordship. This
not
is
regulation?
Lordship. Yes, Lordship. It is the 1991 notification. Lordship. This is 9.0 UGC Regulation 1991 regarding minimum qualification for appointment of teachers in universities and colleges. And the notification is 19/9/1991. Lordship at page 82, Lordship. CA, Lordship. May I read, Lordship? Lordship 3A, under the heading lecturer, Lordship. Arts, sciences, social sciences, commerce, education, physical education, foreign language, and law. Good academic record with at least 55 marks or an equivalent grade at master's degree level in the relevant subject from an Indian university or an equivalent degree from a foreign university. Candidates, besides fulfilling the above qualifications, should have cleared the eligibility test for lectures conducted by UGC, CSIR, or similar tests accredited by the UGC. Number B, journalism and mass communications, good academics records with at least 55 percentage of marks or an equivalent grade at master's degree levels in communication, mass communication, journalism from an Indian university or an equivalent degree from a foreign university. Candidates, besides fulfilling the above qualifications, should have cleared the eligibility test for lecturers conducted by UCC, CSIR, or similar tests accredited by the UCC, or at least 55% of marks or an equivalent grade at master's degree level in social sciences, science, humanities, with at least second-class bachelor's degree or postgraduate diploma in communication, mass communication, or journalism for a recognized Indian university, national institution. Candidates, besides fulfilling the above qualifications, should have cleared the eligibility tests for lectures conducted by UGC, CSIR, or similar tests accredited by the UGC. Lordship, C is music, Lordship. So, Lordship, these are the minimum qualification, Lordship. So, Lordship, NET, SLATE, or PhD is the mandatory requirement, Lordship.
Where the 8 years prescribed period, 8 years
Lordship,
is prescribed?
Since, Lordship, at that time, Lordship, the state was not having candidates, suitable candidates to be appointed as lecturer who are having this minimum qualification. So, Lordship, there were conditions given so that, Lordship, we get better teachers for the better candidates.
That's all right. First, you tell me, which clause of this regulation provides that within 8 years this PhD has to be completed?
Lordship, this was a condition imposed in the Lordship order itself. This,
The order itself is all right, but what is the basis of imposition of such a condition?
but Lordship, here the order is not under challenge, Lordship. In this item, Lordship, that order they have not challenged, Lordship, that the conditions should not be there, the conditions should be withdrawn, Lordship. This prayer, Lordship, and
So, Mr. Upamunya, you admits that this condition is not on the basis of any regulation or rule.
yes, Lordship.
So it is imposed by the director, by the appointing authority
Yes.
on its own.
Yes, Lordship.
Okay.
And Lordship, this condition, Lordship, at page 14, Lordship, has not been challenged in this petition, Lordship. The prayer. Lordship, may kindly have a look at the prayer, Lordship. At page 14, Lordship.
Okay.
One.
Yes.
Number one, equate in the nature of criteria by setting aside and passing the order dated 8/2/2017 by the Commissioner Secretary, Education, Higher Departments, and Lordship, Lordship, the respondent authority to fix UGC scale from the date of regulation, that is 12/11/1993 instead of August 2000.
It may not be there in the petition, but the court has the power to modify the claim.
Lordship, otherwise, Lordship, he has not challenged that. I'm just pointing out, Lordship. And Lordship, even after that, Lordship, he continued providing service with these conditions, Lordship, since 1993 to Lordship 2017, Lordship. That is almost, Lordship, 24 years, Lordship. So, Lordship, I have also 24 years, Lordship. So, Lordship, again, Lordship, that related challenge, Lordship, I have taken a stand, Lordship, that
Related- But when the cause of action is recurring, then this delay will not come.
but Lordship, throughout this 24 years, Lordship, he has nothing to, Lordship, object. Lordship, he was numb, Lordship, he was, so Lordship, delay and laches, Lordship, I am saying, Lordship. And thereafter, Lordship, may have a look at the additional affidavit, Lordship. Yes,
Dated
dated, Lordship.
17 October.
No, Lordship, that is the reply, Lordship, filed by the petitioner. 20th August, Lordship.
Dated 21st of August.
Yes, Lordship. Lordship, here at page 75, at annexure, at para 5, Lordship. Lordship, here I want to submit, Lordship, one thing, Lordship.
Hmm.
He is not even entitled to get this UTC benefit since 2009, but that is rightly, wrongly, Lordship, we have given, Lordship. So
Hmm.
we are not taking it back, Lordship. But otherwise, Lordship, the minimum criteria is to clear NET, SLATE, or PhD. But here he has done MPhil, Lordship. And Lordship, we have stated that the MPhil degree, Lordship, as contended to have obtained by the petitioner, Lordship, it is from a distance mode, Lordship, from Vinayak Mission University of Tamil Nadu, and it cannot be recognized, Lordship, because as per Lordship, central government has
MPhil degree is not recognized.
distance course MPhil is not recognized as per central government, Lordship.
There is a notice.
Lordship, the notification I do not have, but Lordship, I have made a statement, Lordship, at para 5, Lordship. It is not true, my Lord.
Lordship, may I take indulgence plus for 1 minute?
Let him talk. You will get a chance to.
Lordship, here, one thing, Lordship,
No,
on
only
this
with regard to the affidavit.
affidavit, Lordship. Here, Lordship, this suppose on that day, Lordship, on 20th August, Lordship, when I submitted that, Lordship, we are going to file this affidavit today itself, Lordship. So I have served him a copy, Lordship. Thereafter, Lordship, the filing time was over, Lordship, so we could not file the same. But evening, when in the chamber I was going to, there were some mistakes, Lordship. Accordingly, we have corrected the affidavit, and one corrected copy was served to him, Lordship.
No, that
But
is wrong.
Lordship, even if it's not submitted to him, Lordship, then Lordship, I tried to submit him today itself once, Lordship, since I have to take that, Lordship. I have checked with the office records also, corrected affidavit is there, even my copy is also corrected, but his copy is not corrected. But anyways, Lordship, based on my, Lordship, that there was some mistake, Lordship, since I have submitted him on the earlier day, he has filed his reply, Lordship. So that point, Lordship, I will not raise, Lordship, any objections, since, Lordship, I have served him a copy, which there were some, Lordship, typographical errors. Later on, I tried to furnish him a copy, Lordship. Today also, I have tried to furnish him a copy, but he is not accepting it.
On
So, Lordship,
21/2025 at 11:55 AM, he has served me this copy. And on the basis of this contents, Lordship, I have filed my reply on 17/10, Lordship. Now, just today, Lordship, just before half an hour, Lordship, he said me that I have submitted a corrected copy for the honorable court,
No,
and he wanted to serve me this copy.
no, Lordship, I have served him earlier also.
On the basis of the copy he has served,
I have
Lordship, I have
served him
filed my reply.
the corrected copy also, it was served on that day itself.
No.
Okay.
But Lordship, anyways, Lordship, now I can
Otherwise,
give
I
him
will-
right now also one copy, Lordship. But anyways, Lordship, we have filed a reply on the first affidavit.
If he had given me, then I would have filed my reply on the basis of the corrected copy. He has never
That's
served
why
me
I
the
am
corrected
submitting,
copy.
Lordship, that there was some mistake. I am not hiding the fact that there were not any mistake. There were some mistake, Lordship. So I have given him the corrected copy, Lordship. But even if he,
So, is there any difference? that the
yes, Lordship,
corrected-
there were some typographical error in his
Typographical.
copy and the copy which I have filed, and we have also given him the corrected copy on the day of filing. And based on that wrong Lordship affidavit, he has filed his reply. So there are some statements, Lordship, which Lordship I am not going to, Lordship.
Lordship, he has served me the copy on 21/8/2025 at 11:55 AM. I have also written,
No,
on the basis of that affidavit, Lordship, I have
no.
filed my, yes.
You have gone through the corrected,
No, I have never got
Affidavit.
my corrected copy.
you have not gone.
Today only he has just said me,
No,
just before, half an hour, he has said that,
No,
I have-
see, whether there is any requirement for filing reply against the corrected.
I don't know, Lordship, what he has corrected. Lordship. Only from
Lordship,
his, Lordship, I have come
Otherwise,
to know.
there are,
No, anyway, Mr. Opponent, you complete. your-
yes, yes. I can give him also right now also.
Ah.
This is the second time I am giving. Okay, typographical error. So
Yes.
Lordship, that I have given him again, sir. So anyways, Lordship,
First time, okay.
so Lordship have asked me the regarding that conditions, why those conditions were imposed, Lordship. That also I have taken the stand in page 76 at para 6, Lordship. That that this condition was a conditional approval for appointment was granted to the petitioners, as at that time the candidates with net slate qualification were not available, and without satisfaction of the UGC norms, full salary for the underqualified lecturers would not be justified. The specification of net slate qualification along with excellent academic career for appointment of faculty members is intended to ensure standard of excellence in higher education, and dilution of requirements would hardly serve the public cause. Lordship, that's why, Lordship, we have put those conditions, Lordship, in the appointment.
So, you clarify another thing, whether these conditions are only in respect of the present petitioners or in respect of other teachers or lecturers
Yes,
appointed.
Lordship, these conditions were, Lordship, imposed to other petitioners as well. Not petitioners, Lordship, but other candidates as well. Okay, yes.
So, my lord, this is my lord.
It
I
is not the
sorry to
fact that
interfere.
only these two people are having these
One-
conditions, Lordship.
One thing, my
There
lord,
were other cases, Lordship, I can give a list of this matters, Lordship. Few of them also came before this court, Lordship. So those conditions I can show, Lordship. Those petitions.
Okay.
The
My lord,
conditions are there, Lordship.
regarding Lordship, my lord, clearance, Lordship to get in order reception of 6/1/2025, the next case, where my Lordship has specifically asked the question, queries, that whether you have strictly followed this criteria throughout the appointment process during that period, or you are, my lord, in second mood you are preferring. So, to that extent, they are asked to file an affidavit, but they failed to file the affidavit. I am coming in my case also, my lord. That was a very specifically, that was a question put by the court.
But Lordship, there are other people also, Lordship, in whose Lordship appointment these conditions were there. It is not that only these two people are having this conditional appointment. And Lordship, they have accepted this condition, and Lordship, they have worked also. And their reply is that since they have to go through their family and they have to provide food and shelter, Lordship. So out of necessity, Lordship, they have accepted those conditions. Lordship, that statement they have given in this matter, Lordship. Other than this. So Lordship, these conditions were imposed just because that time, Lordship, there were no candidates having net slate. So for Lordship, giving them a chance, Lordship, we have given this condition, Lordship. And Lordship, even though Lordship, they are saying that these conditions were not imposed to similarly situated candidates, and only they were the ones who were the victims of this condition. Lordship, or even though they say that these conditions were there in other petitioners' cases also, but we have relaxed these conditions and we have given them UGC scale of pay from the date of regulation. Then also, Lordship, if there is any oversight, Lordship, they cannot take the ground of negative equality, Lordship. Lordship, rightly or wrongly we have given it to someone else, Lordship, when we have realized that this.
No. In order to take the benefit of negative equality, you have to admit that you have committed some mistake. and by mistake you have given the benefit to some of the candidates.
Yes, Lordship, it has been mentioned, Lordship, in my affidavit. We have taken this step.
No, in respect of negative equality, I am telling.
Yes, Lordship. Lordship, page 77. Lordship, same Lordship, page para 7, Lordship. The answering deponent further begs to state that the prescription of law is that a lecturer, in order to be appointed and become entitled to UGC scale, would be required to clear net slate PhD. Therefore, if any person has been appointed as a lecturer without such qualifications, such an appointment cannot be said to be in accordance with law. Further, even if some other were appointed under same advertisement and were given the UGC pay scale without having cleared net slate PhD, or their appointments were approved without any condition with a regular UGC pay scale, the petitioner would still not be liable for the same benefit by applying rule of parity. In view of the above, it is respectfully submitted that one wrong committed in one case cannot be allowed to be repeated in another case, as there is no.
No, no. In which case you have admitted that you have committed
No, it is the petitioner who is, Lordship, submitting that we have given other candidates also, Lordship, we have given some benefits, and without the conditions also we have given appointment, and even if there were conditions, Lordship, we have given them UGC scale of pay from the date of regularization.
Sorry, this omnibus statement on your behalf. It cannot be accepted.
Lordship, the petitioners were saying that they were given benefits.
Any other point?
Lordship, I will go by my affidavits only, the
Affidavit.
statement. And Lordship, few judgment, Lordship.
Yes, madam,
I'll give a list
whether
of it.
UGC prescribe any such time period for completion of this PhD degree? No. It is not a requirement.
Not required. The candidate wants the contract. I have qualified net or debt, and if net or debt is not there, then it has to be but
Both the-
I am object only item number 20 that we added as a responsibility. In this, the neither had net, not debt, nor the none of these criteria was fulfilled. So UGC profit not at that point. Subsequently, it has been has certified by the indicator and after that, if not, but this particular of the provides that they have either it is or within a period of year on the basis of that years of as for the not for the either net qualified, not net qualified, not
Lordship, that is the minimum requirement, Lordship. Okay. But in this matter, Lordship, since they were conditions, Lordship, and since they have qualified for, they have done their FPL, Lordship, we have given that. This was also not supposed to be haven't been given to them. This was wrongly given, Lordship, by the department. Not for.
Okay.
Lordship, few judgment, Lordship orders, I will just write it down. Lordship.
Okay. Yes, Mr. Das, what is your reply?
Lordship, my reply is, Lordship, the petitioner was appointed in the year 1985, Lordship.
Hmm.
My appointment was, Lordship,
Don't repeat the same
20,
thing.
24
You
for,
come to his reply only.
yes, 24 for 1985. So this UGC regulation notification he has referred of 1991, that will not be applicable in my case. And secondly,
Why,
Lordship,
why not applicable?
because my initial appointment was in 1985. And this notification he has referred is 1991, and that particular notification has come into effect and has been implemented by the state government only with effect from 13/1/2000 in the state of Assam. That has been implemented on 13/1/2000 law. And my initial appointment was 1985. And with
Is there any notification of the government of Assam giving effect of
It
this
is, it is, my
notification?
lord, in my.
in the
my
second
petition,
reference.
I have annexed and they have also admitted, my lord. It is 13 January 2000, from that day, my lord, in state of Assam, the UGC regulation has been completed, so party, my lord, net and split is concerned, not prior to that, my. There is a specific notification. That is also admitted by my line.
Annexer?
This is my lord. They have also admitted in their affidavit. So I have annexed further with my affidavit, my lord. It is filed on 11/4/2025. That is filed on 11. Serial number case file of 66 of my case second, my lord, 23. In their affidavit also they have admitted. UGC only the, my lord, is formulating the regulation. They are not the implementing authority. State is the implementing authority. From which date the state will implement, that will come into count. Not the UGC that saying that it's 91, this is the regulation. If the state is not followed, this is not complement, this is not mandate. This is as per the notification. The government has to take the, well, okay, follow this, well, the UGC guide. This is the thing.
And
Very
Lordship,
clear.
yes. And at that point of time, Lordship, the pre-revised UGC norms was there, 52.5. That has been reflected in the judgment, Lordship. In my writ petition, page 16, Lordship. Page 16, relevant portion is page 20. At that point of time, it was the pre-revised UGC scale norms, Lordship, 52.5 in master's degree. 55, Lordship, that has come only from 1186 revised UGC norms. And secondly, Lordship, the similarity of person, Lordship, that I am praying for similarity of treatment. Those examples I have already given, Lordship, Pratibha Chaudhary, Aparna Tamboli, and they have also put them to show cause. Thereafter, Lordship may kindly see one order, Lordship. My imping order, Lordship, may kindly see, which I have challenged at page 45.
45 of your petition.
Yes, Lordship, this is the order which I have challenged.
Yes.
Lordship, I am just second from last paragraph, Lordship. Whether Director of Higher Education Assam has been asked to furnish and find out if such benefits were extended and to whom and when the Director of Higher Education has given his opinion by letter number so and so, that the illegal benefits granted to some cannot be cited as a precedent by the petitioner to sustain his claim. Further, Director of Higher Education Assam has issued SOCOS notice to Arpana Tamboli, lecturer ADP College Nagaon, who has been allowed regularization benefits from the date of joining, although she acquired MPhil in 2010. On facts and circumstances above, Ohiruzaman is not entitled to get the regular pay of UGC scale from his original date of joining against sanctioned post, that is 12/11/1993, but eligible only from August 2009, the date he acquired the qualification. This order I put to challenge, and in this order itself, Lordship, they have given SOCOS notice to Arpana Tamboli. And Lordship may kindly see Arpana Tamboli. Till then, Lordship, the amount was not disbursed. Then I made an RTI application, Lordship. In the RTI application, Lordship,
No, that
Yes.
benefit given to the
Yes.
employees cannot be recovered in view of the decision of
no,
Supreme Court in Rafiq Masjid's case.
yes, Lordship, I admit that. But here is a SOCOS, Lordship, on 8 February 2017. The amount they have disbursed is on 27 March 2017, Lordship may kindly see. Page 48. Rafiq Masjid case will be applicable in other cases. But here they have put SOCOS notice to Arpana Tamboli in the month on 8 February 2017. and they have disbursed the amount, they are aware of the fact. Then they disbursed the amount on 27 March 2017 at page 48. Amount of 14,98,287. Okay. Okay. And also earlier given the judgment of similarity of treatment, also Ramesh Goswami and all.
That they are.
Yes.
Yes, Mr. Moto, anything to submit?
My lord, two things, my lord, I like to it, my lord. So far, my lord, the appointment is concern of the petitioner in the year, my lord, 92 advertisement and appointment was approval was given on 94. My lord, the kindly see, my lord, the advertisement, my lord. This is annexure 2 at page 28.
Next,
Annexure 2 at page 28, my lord, of my report. I'm very short, my lord, I am submitting this all the
Annexure,
2 at page 28, my lord. Of my writ petition, my lord. There is an advertisement in respect of the two colleges. My college will come the bottom one, my lord. The application will attach copies of the certificate and the mark sheet from the SLC onwards will be received from the undersigned up to 4 substances for the sanction post of the lecturer in Assamese Group B, Economic, and by the political science. My post is, my lord, political science. In the same advertisement, other two posts were also advertised, and the all, my lord, two persons, they were also appointed along with me. Kindly turn to, my lord, the appointment in respect of the one of the lecturer of the same advertisement, same sanction post, my lord, the creation number. This is annexure 12 at page 40. Same petition. Same advertisement. Where it is economics, my lord. Lordship got it, my lord. Bhairav Chandra Das. Kindly see, my lord, in his appointment, my lord, no such condition was there. He was given the, my lord, full easy scale. With the same qualification.
okay.
Sir, no, my lord, another also, my lord, the same college, the another appointment also I am coming, my lord. Lordship, kindly turn to my reply that is filed on, my lord, just before I saw it, lordship, to the notification, the same affidavit. Where also the second person incumbent in respect of the Assamese, I have annexed, my lord. It is page number 71. Serial annexure 2, where it is Assamese lecturer, the same post, same advertisement, my lord. He has been appointed without putting that type of conditions, my lord.
But lordship in both the
Let me finish. I'm interfering, not interfering. So my first contention is the same, my lord, the advertisement is same, the post, my lord, were different, the process are same, the same criteria, same qualification. Once the appointed with the same other qualification and another is putting the other qualification. And this is my lord, objection on that. Second, my lord, so far, my lord, the qualification is concerned regarding there is relying that they added 11 times the UGC, this NET slate was, my lord, followed, and the PhD was a compulsory subject. This is for the qualification in addition to 55. My lord, kindly lordship turn to my writ petition, annexure 11. In earlier occasion, so I relied these same things, and lordship put the queries also on that issue, my lord. Where one letter, it has been written by the director to the minister concerned of education, where, my lord, all the qualification in year wise, it is being shown, where lordship will get the from bottom, it is, my lord, the first, second, third line, third but fourth, my lord. So it is showing the on 1-1, my lord, 89 probably, my lord. The qualification was 55 in master degree only. Then next, my lord, lordship will come with 1-1-96, minimum qualification 55 marks in the postgraduate from the for unreserved category, clearance of NET oblique slate, and B minimum 55 marks for the post of the OBC scheduled caste ST category, clearance of NET and slate, my lord. So from this letter also, it is clear that on the day of my appointment, the qualification only to the extent of 55% of marks. No net slate or MPhil was necessary at that time. Moreover, my lord, my learned my lord,
Appearance of net slate is there. That,
from 90, it is, they are showing that from 96 onward.
Oh.
So my appointment was for a 92 advertisement and appointment approval was 94. So my next one, my lord, their affidavit, my lord, my learned friend, my lord, representing the state education department. In his affidavit, my lord, he has specifically stated in para 11 of his affidavit, my lord, in the page number, I think 55, 54, he started last portion, my lord. Although he is relying the all the UGC notification, but he admitted the state government has accepted this net and slate from which date. So where is the last paragraph, let's say we come to, accordingly, as per UGC regulation 1998, issued on 24/7/98, net slate is mandatory requirement for appointment of lecturer in colleges. But Government of Assam notification net slate as mandatory requirement eligibility criteria for the appointment of lecturer in colleges throughout the state of Assam, by such dated 13/1/2000, my lord. Same notification, I relied my reply. He did not annex these things, I annex, my lord. Wherefrom it is clear that the state government, although my lord, the UGC has, my lord, state some qualification for appointment of lecturers, professors, readers in all the colleges and universities.
Which paragraph of their affidavit you have referred to?
My lord, the here affidavit, my lord, paragraph number 11, it is a long paragraph, my lord. It started from page number 52, and the last, my 11 portion will come, lordship, in 54. Bottom paragraph, my last paragraph.
Yes, the date of effect is 13/1/2000.
2000.
That is.
My lord. So the state of Assam, my lord, that is why the other applicant who were, my lord, who are already, my lord, interviewed in the along with the same along with me in the in person the same advertisement, this condition was not imposed on them. But why this condition is imposed, I also explained that at that time, my lord, my learned had also admitted that certain underqualified, my lord, lecturers were appointed because the all qualified lecturers have some scarcity for appointing, and the net and slate in all subjects were also not conducted during that time. So there is a cyclostyle process of issuing the appointment. So in mistake, my lord, this condition was that should have been imposed in an underqualified candidate lecturer, that has been imposed on me. So in 2006, well, I have specifically mentioned, whenever these things was pointed out by the All Assam College Lawyers Association, this is called All Assam College Teachers Association, my lord, ACTA, then certain numbers of, my lord, this type of illegal condition was imposed to the other lecturers also. There, this condition was removed, but accidentally that condition was not removed. So that was been continuing. So on that issue, I should not be deprived, my lord. So whenever the process of appointment is, the parity should be there. There is a note saying for a particular section of people, there will be different qualification, different process, and for the particularly another person, there is different process for the same appointment. That cannot be, my lord, followed. So parity must be there. So following this parity, the principle of this equality should be followed in respect of me also. So this is my submission before lordship, because I am retiring this, my lord, 26 March. So my lord, lordship may, my lord, realize the people, my lord, on retiring, what is their expectation in retirement benefit, my lord. So somebody is getting the more, my lord, retiring benefit, and I am not getting. That will be a great, my lord, injustice, and when that turning to me also, my lord. So that is the my only humble submission before lordship. The parity should be there, and they have whenever admitted the entire things by themselves. Then what is the objection, my lord? And I have showing on the appointment letter, similarly situated person, my lord, in the person of the same advertisement. Nothing was there, my lord, in respect of me only.
Okay.
Master.
Yeah.
Okay, just take 2 minutes, but
Mhm.
my learned senior has just referred to Annex 11 of the rich petition and stated that these criteria for being appointed are of the state, but this notification needs to be read in toto, and especially the second and third paragraph of the notification. Page number 42 of the writ petition, Annex 11.
Yes.
If I may read that. In 1970, the second paragraph first. In 1970, the government of Assam decided to allow UGC scale of pay to the teachers of the GIA colleges by government notification number so and so dated 23/1970. Since the benefit of the pay scale was agreed to from 1/1/1973, and general notification was allowed to the teachers appointed prior to the cabinet decision dated 18/8/78, and this is important dot, and debarred further appointment of teachers having no UGC norms. The UGC has modified the norms time to time for appointment in the post of lecturer in colleges, which are as follows. Lordship, out here 1989 and thereafter directly 1996 has been mentioned. But we have already shown the notification of 19 September 1991. The 19 September 1991 notification has not been mentioned in this particular notification. This is a mistake. The 1991 notification has already been adopted because as per the cabinet decision of 18/8/1978, the further appointment of teachers having no UGC norms had already been debarred. That was the cabinet decision. And it is very much clear from this page number 42, Annexure 11. So it cannot be said that the UGC regulations were adopted only from 30th January 2000. This notification dated 19/11/2002 clearly shows that the cabinet decision of 18/8/1978 had debarred further appointment of teachers having no UGC norms.
Your notification is there, but the state of Assam has made the same applicable
this-
from that date.
This notification at page 42 is issued by the state of Assam, and it is written by the state of Assam that as per the cabinet decision dated 18/8/1978, further appointment of teachers having no UGC norms has been debarred. Paragraph 2 law. This may kindly be taken into account.
Regarding Lordship, similar candidates were to Lordship appointment without condition, Lordship. Here, Lordship, we do not know whether they have the qualification or if they have the qualification, minimum required qualifications, we will not impose any conditions to them. But
55, whether you have to mention these things. I don't know what type person is waiting, my lord.
No.
My lord, whatever submission is there, notification from this lordship will clear from the notification is January, my lord.
Raised by my learned friend. I have retired in 2017. Those were never raised during my service period. Now they cannot raise.
That should have been mentioned in the appointment letter.
2017 I retired. Okay. We'll not fix any date, but we'll upload the order very soon.
My lord. My lord, this is it regarding his, my lord, this is standing council. This is clarified by the notification that is 13 January 2020 by the state of Assam, my lord. From this, it is very clear, my lord. Everything will be clear from this notification. Master Ambedkar.